Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. So without any further ado, I would love to introduce our moderator for today's program, Stacie Hausner, who will then introduce our other panelists. Stacie Hausner has mediated thousands of cases in the areas of personal injury, civil rights, employment, business, real estate, insurance coverage, construction defect, malpractice, and entertainment. She's been a mediator for 10 years and an attorney for 27 years. She has an LLM in dispute resolution, has been teaching mediation at Pepperdine Law School for the last 8 years, and has been training mediators through the Central District Court Panel of Mediators, the Mediating and Litigated Case Program at the Strauss Institute, and many other mediation organizations. Thank you for moderating our program and pulling our panel together today, Stacie.
Well, thank you, Katie, and welcome everyone. Thank you for joining us today. We are thrilled to have a record number of attendees for this special webinar. And it's really no surprise given the incredible lineup of panelists we have here with us. These attorneys are some of the best trial attorneys in our community, known for their exceptional skills and impressive track records. While they do most things right, even the best face challenges and unexpected twists in their practice. Today, we have the privilege of hearing from these legal legends about how they navigate these shaky waters when things don't go as planned. I'd like to introduce the panelists who humbly have given me a 3-sentence introduction of themselves, which is obviously a very abbreviated version of their illustrious careers. I worried that if we didn't do a shortened version, it would take me the entire hour to share all of their accomplishments. So I encourage everyone to check out their websites, and I will introduce them in their own words. Gary Dordick is the founder and owner of Dordick Law, a plaintiff personal injury litigation firm. He has tried over 150 Superior Court jury trials. He is in the Calla Hall of Fame, has multiple Trial Lawyer of the Year awards, and has been the Daily Journal's top plaintiff lawyer and top 100 lawyer in the state many times. Linda Miller Savitt, who is a partner at Ballard, Rosenberg, Golper, and Savitt, where she defends employers, gave me the following 3 sentences. Linda has tried over 100 jury trials. About 85 to 90% have been defense verdicts. Most of them have punies, and she was only hit once for punies. Great. Dana Fox is a partner in the Los Angeles office of Lewis Brisbois. He has been practicing for 38 years and is a member of the American College of Trial Lawyers, the International Academy of Trial Lawyers, and the American Board of Trial Advocates, ABOTA. Dana specializes in high-profile, high-exposure jury trials. Fun facts: Dana's daughter, Kelly Fox, is an attorney who works with legend Linda Miller Savitt. And Dana is the bass guitar player in the locally renowned rock band Too Loud for Larry. Morgan Chu, a partner at Irell and Manella, gave me a funny introduction. He would like you to know that at his first trial, he did not know where to stand for his opening statement. Yeah, he's come a long way since then, obviously. Fun fact: for decades, Morgan held a world's track record. He and his friends went through New York subway system stations in the least amount of time on one fare. 22 hours, 11 and a half minutes, beating the prior record of 22 hours, 18 minutes, all validated by the Guinness Book of World Records. So thank you, Morgan. Okay, without further ado, let's dive right into these legends' experiences and insights on handling the unexpected. And let me start by asking each of you, can you share one of your more memorable examples of a trial where things did not go as planned? how you adapted, and any lessons learned. And let's start with you, Linda, and then the rest of you can jump in.
So this is a hard question to answer because every trial, it doesn't go like it was planned or it was supposed to go. And you have to be able to adapt. I think the key to dealing with that is to sort of put whatever happened into perspective and try to explain it to the jury in perspective. I do remember a disability discrimination case I tried about 10 years ago. And it was a tough case because lawyers are always tripping up on disability. And the disability coordinator got on the witness stand and was by far and away the worst witness I have ever seen in my entire career. She was horrible. And she was like the key decision maker. So I after tons of pulling testimony out of her, I got her to testify what she had done. And when I argued it to the jury, I said to the jury, you know, Miss So-and-so, probably the worst witness I've ever seen in my entire life. She was terrified up there. But you can't judge her based on whether she was afraid on the witness stand. You have to judge her on who she is. And then I went through her background, how committed she was to disability. She'd had like 5 jobs. She had a degree in disability discrimination, how to combat it. She worked for all these private nonprofit corporations. I said, she did everything for him to help him find a proper accommodation. She just couldn't get the words out because she was so afraid. So you can't judge her like she's an actor on TV. You have to judge her by the substance. And I really tried to put it in perspective. And I think that ended up being effective. I think it gave me credibility because I told them she was a horrible, horrible, horrible witness. And, you know, we lost the case because it was a tough case to begin with, but we kept the damages down, which was the ultimate objective. And I think the jury kind of got that it wasn't how you testify, but as to what you testified to, even if you testified terribly. So I put it in perspective. That's the one that stands out in my head. The rest of them, they're all a blur. But you just deal with them.
All right, Dana.
Well, I'm going to call this if everyone remembers the old Southwest commercial, want to get away. This was my want to get away moment in a high exposure trial. I was lead trial counsel. And to set the stage a little bit, it involved a vehicle accident, a single vehicle accident where the plaintiff was a passenger in my company driver's vehicle. And as a result of the accident, the plaintiff, a lovely man, a wonderful guy, was rendered paralyzed. And he was permanently paralyzed the rest of his life. 2 days later, they did some spine stabilization surgery. And while undergoing surgery, he had a rare but reported optical stroke and went blind in both eyes. So this man went from being a healthy 50-something-year-old guy to being paralyzed and blind in the matter of 48 hours. It was a very sad accident, and he was just a tremendous guy. And we were about 3 weeks into the trial. And one of the other messages is, when you're polite and professional and organized and respectful to everybody, it has a payoff at the end. You should do that anyway, right? We should all be civilized toward everybody, but it has a payoff. Anyway, 3 weeks into it, I'm cross-examining the plaintiff's life care planning expert. And she had prepared a report, and it was very small, and we didn't have it loaded on the computer for some reason. And there was an Elmo, so I said, no problem. I have one page. I can just use that. And by the way, an Elmo can still work. And I put it on the Elmo, and when I put it on the Elmo, the print was extremely small. And I was on a roll, I was just moving, and I said, oh, hold on 1 second, Ms. Expert. Let me make this a little larger so I don't make you go blind. I couldn't believe I said that. And I heard it, and I felt my heart fall into my ankles. I got all flush. I got all hot. I knew I had screwed up. And I remember after that, all I heard was like that Charlie Brown sound of wah, wah, wah from me talking and her talking for the next 5 minutes. I was petrified at what I had done. I sat back down. I had co-counsel. I leaned over calmly. Of course, I didn't freak out. And I said, did you hear what I said? He said, I did. I said, I can't believe it. He said, relax. And the next break, I was sweating. And he said, you know what, Dana? the jury likes you because you've been decent for 3 weeks. They like you. They're not going to be mad at you. And so you're just going to have to let it go. And I couldn't. And in closing argument, I actually apologized to the plaintiff and said, I'm sorry for that inconsiderate comment. I felt I had to do it. Of course, 9 of the jurors came up to me after and goes, what was the comment? We don't know what you were talking about. So they hadn't even remembered. So the takeaway is this. It kind of what Linda said, the things that you think are awful and terrible are maybe not as awful and terrible as you think they are. And there's always a way to adapt and move on. And the last thing I'd say is, never let them see you sweat. Just move on, just keep going, and don't panic. Because if you panic, you can't think straight.
Thank you for that, both of you. Thank you for your stories. Okay, Morgan.
First of all, Stacie, thank you very much for this invitation. This is great fun for me because everyone on this panel has different backgrounds, different practice experiences, and I usually do business cases. I've done First Amendment cases, antitrust. In recent years, I've also done a lot of technology-related cases. But one instance comes to mind. And it happened, Stacie, that it involved your dad's law firm. And here's the background. In November 1979, militants in Tehran invaded the US Embassy, and they took over the embassy. And then 52 Americans were held hostage for 444 days. If you were a child, a teenager, or adult in the United States, you will remember those times. Walter Cronkite, the anchor for CBS News, signed off every night. He would say, this is the 198th day that Americans are being held hostage in Iran. I represented the lead reporter in a story that was released after the hostages were set free and returned to the United States. Only one of the hostages was not a US government employee. He had a checkered background, he spent time in a federal penitentiary, and the investigative reporters pointed to evidence that suggested strongly that he had been in Iran for a drug-related transaction. All Americans had been warned for months not to go to Iran, or if they were in Iran, to leave. Some of you may remember from law school an old Supreme Court case, New York Times against Sullivan, which stood for the proposition that if one was a public official and later a public figure and was in a defamation or invasion to right to privacy lawsuit, there were some extra constitutional protections, which meant the plaintiff had to prove actual malice as opposed to just negligence in order to recover. We had this theory that this one private citizen was, in fact, a public figure of his own choice, despite being held in captivity, because he made a videotape broadcast worldwide many times that said, bring the Shah home. The Shah was in the United States. The Shah had been deposed. The people running Iran at the time wanted him to be brought home, no doubt to be put on trial and then executed. So our theory was that even if in captivity, you could make voluntary statements. So here's the surprise. At lunch, it was a 3-week trial. Plaintiff's counsel say, oh, well, we have this witness. They forgot to say surprise witness, who's going to take the stand right after lunch. He is the Bishop Thomas Gumberton of Detroit. During the first Christmas, 3 well-known clergy people had visited the hostages. It was him, Bishop Gumberton. It was William Sloane Coffin, who was the pastor at Riverside Church in New York and the chaplain of Yale, and another well-known individual. So they called him to the stand, and he said, I visited the private citizen who's the plaintiff in our case, and he was beaten up. He was in a dark, damp cell. People had AK-47s around him. His hands were bound, his feet were bound. The whole point being that any statement he made, any videotape he made, could not have been voluntary. So there were two other lawyers, much better lawyers than I was then or now, both fellows of the American College of Trial Lawyers. One was Dan Fogel. He was representing the publisher, which was the Tribune Company. And Stacie's dad, Larry Feldman, was part of Fogel Feldman, a fabulous law firm. Bill Masterson was also a very well-known lawyer, and he represented Carol Burnett and many others in various First Amendment cases. Very, very well-known. Direct examination of the bishop ends, and Dan leans over and says, looking at me, I'm not going to cross-examine him. And Bill Masterson also staring at me with his cold eyes, and I had known Bill for a number of years, says, I'm not cross-examining him, and he puts his hand on my wrist. So I'm a young kid, got to take some chances in life. So I said, oh, I have some questions. So I get up and asked the bishop, I said, you visited, it was well known in the public record, the other hostages he visited, you visited Corporal Johnson. Yes, I did. What were his condition? He was beat up, he was bound, held in solitary confinement, AK-47s around him. You visited John Jones. He was the second secretary of the embassy, same thing. You visited these other hostages, same thing. And then I said, did the corporal and the Marines make any videotape, make any public statements? No. And I went through the others that he visited, and he said no to each of them. And I sat down and I looked at, I know that both Dan and Bill were pretty upset with me, the young kid, when I got up to ask questions, when they were telling me very clearly, don't cross-examine. But they said, way to go, kid. That was pretty good. So I smiled. And sometimes it's easier to take the safe course, particularly when seniors who are fabulous lawyers are telling you what to do. But I took a risk and had fun.
All right, thank you for that. And Gary.
Well, thank you for having me. This is a great panel to be on. Thanks for putting it together. You know, what impresses me is each of the panelists are able to recite a particular trial where something went wrong. And for Morgan, the last time something went wrong was apparently in the 80s. For me, every single trial, stuff just goes wrong. Now, maybe you guys are thinking, well, Gary, you should prepare more. But the reality is, and what we do is fluid, and there's so many variables. When we talk about things going wrong, the Elmo doesn't work, the PowerPoint doesn't work, the witness doesn't show up, the judge excludes your major piece of evidence. And so part of what Dana was talking, by the way, Dana, I got a sense that that trial didn't end well. It didn't sound like the plaintiff got a lot of money from you telling the story. And you can be sure when he tells the story, it didn't end well for us plaintiffs. But we always look at it like plan on the, like for PowerPoints, I print them out. Just in case it all goes, I'll put them page by page on the Elmo. I'm always looking. If that witness doesn't show up, I have something else. If that document that may get excluded, I always, in my preparation of my notes, have a plan A, plan B, plan C for everything that we do. I'm always assuming it's going bad. Maybe it's just because I live life that way, or as a plaintiff lawyer, I see how things go bad all the time, but I'm always anticipating it's going to go wrong, and I have a plan. And I think the most important thing, as Dana said, that what we get from having the experience in a courtroom is, for example, when something goes wrong and it's quiet, lawyers melt. 5 seconds, 20 seconds sounds like an eternity when everyone's looking at you and nothing's working. And what we learn with experience is it happens. The way we deal with it is like, I'll look at the jury and that long, awkward pause, and I'll say, I forgot what I was going to say. And they look at me like, I do that all the time. This guy's just like me. Or I tell them it broke. And it, like Dana said, stay cool, figure it out. If you need to, ask for a break. But oftentimes, the more you struggle, the more they see you sweat. They feel for you. You're human, you're real. So just do the best you can. And if there's a problem, tell them what the problem is. Be open about it, but always prepare for just about everything to go wrong and deal with it as it comes. And one day, like these folks here, I'm going to have a trial where things don't go wrong, but I haven't had that trial yet.
So if I could just play off of something Morgan said, because he said it kind of in a cute way, you've got to take some chances in life. Well, that's what you have to do as a trial lawyer. And you really, you have to use your instincts. They always tell you never ask a question you don't know the answer to. Well, generally that's a good rule, but there are a lot of questions out there that the answer may not hurt you if it goes against you, but if it goes for you, it's really helpful. So you ask the question because you take chances in life. I had a case not too long ago. The very disgruntled employee was going to give very harmful testimony about my client. Of course, he didn't know what he was talking about. And he shows up at the trial on video with a lawyer. And I don't know why the plaintiff didn't object, but I said, why do you have a lawyer here? You're testifying in court in front of a judge. You know, the judge is going to control the proceedings. Why do you have a lawyer? Oh, well, I just thought I needed one. I said, who's paying for the lawyer? I had no idea, but I kind of had my suspicions. He goes, oh, the plaintiff's lawyer. Okay, so all of a sudden, his testimony was under terrible scrutiny by the jury. He wasn't trusted anymore. I didn't know the answer to the question. If he said I was paying for the lawyer, which I didn't think he could afford, it wouldn't have hurt me. But if he said what I hoped he would say, and my associate said, how did you know to ask that question? Sometimes you just take chances in life, you know, and you judge your witness. I had a cardiologist on the stand one day. He was the plaintiff's expert. I was brought in as a last minute trial counsel, so I wasn't at the deposition. I thought he was pretty straight, you know. So he put her on disability, the plaintiff on disability. So I said to him, let me ask you something, doctor. Was it your idea to put her on disability or was it hers? And he looked at me and he said, it's always the patient's idea. It's never mine. And I got great testimony because you took a little chance on a question you didn't know the answer to. So, you know, use common sense. You got to be fluid. Everything goes wrong all the time and it could backfire. But, you know, if you measure it right, it'll probably help you.
Well, I think that idea to not ask questions you don't know the answer to is part of the old school. That's how they taught us from Hornbook law. But in reality, we realize we have to do it a lot. But as Linda said, you measure it like how bad can it go? And oftentimes I have a response to A or B. Generally, it's one of a few answers, and I have a plan for either way. But in true trial greatness, it generally is shown in cross-examination and closing argument. And oftentimes those spontaneous, really persuasive moments come where you stick your neck out a little bit. You hang that question out there. You say to yourself, should I go one more question? And old school was no. Currently, you think, I'm feeling it, and you go for it. And when you get it, it's the greatest feeling ever. And when you take it right between the eyes, you smile like, oh, that was what I was expecting, and pretend that's what you wanted, but you have a plan for where you're going. But I do agree with everyone here. You just got to take the chances. This is an adversarial system. It's live, it's real, it's human beings, and go for it. It won't decide the outcome of the case, I assure you.
Another area where there's a balance of risks is when to object, whether it's an opening statement, closing argument, or a questioning of a witness, because the objecting attorney can appear to jurors to be obstructionists. And usually when we're objecting, that's our goal. We're trying to be obstructionists in a way, in a professional way. I had a case where the judge, once in a while, would ask questions of witnesses. She followed the case very closely, but generally didn't ask questions. It was a jury trial. And at one point, she started to ask a series of questions of a particular witness. And without thinking, I just stood up and say, I object. And she looked at me and said, Mr. Chu. And I said, well, I object, Your Honor. I did, since I was already standing, I already objected. I couldn't back off. And she said, overruled. I said, I thought you would say that, Your Honor. Thank you. And I sat down.
That's like the verdict. You say to the judge, I don't mind you trying my case for me, just don't lose it.
Well, let me ask you all this. So I hear you have a backup plan when evidence is excluded that you think should get in. What do you do in the situation where new or potentially damaging evidence is introduced unexpectedly from the other side? And let me start with you, Dana, on that.
You know, if you know your case and you're prepared, there shouldn't be new or damaging evidence that comes in. But let's go with the hypothetical that because you dropped the ball on something, you didn't take a deposition of somebody and the plaintiff had disclosed that person and for some reason you depose them and it comes. There's always a plan B, everybody. There's always a plan B. Sometimes look at that evidence that's coming in and look at what's not there. Instead of what's there, figure out what's missing from it and look at that and see if you can exploit that. Because sometimes it's not what's on the piece of paper, it's what's not on the piece of paper. Or if it's a report, what they haven't referred to or relied upon, or there's a gap in what their conclusion is. So stay nimble, just be thinking what's not there, what's another way to deal with this. I keep saying this, there's a plan B. Is there a witness that you can call that can deal with this? Is there an exhibit that you can use that's in your arsenal that's sitting in that exhibit binder that you can use to deal with it? It's rarely as awful and terrible as you think it is. I think that's a recurring theme here, right? And then just figure out how to manage as best you can. And then when your next break, pick up your cell phone and call your client to say, we had a little glitch today, and be honest with them and deal with that. You know, trials are a very fragile event, right? What's Mike Tyson's line? Everyone's got a plan until I punch him in the face. And everyone's got a plan, and then something like that happens. And every once in a while, when you're against a Gary Dordick and you think, I didn't see that coming, and you've got to say, that was well played. Good for him. That was masterful. And that's okay as long as you're honest with your clients and you tell them, look, this is how I think it happened. I did the best I could. I managed it the best I could, but I think he scored points with that. And that's okay. Because I know Gary's doing it with his clients if it goes the other way around.
Well, I think the defense sees it a little less than we do on the plaintiff side, because Dana's right. When you know your case, you have your trial exhibits, you go over them in pretrial, there shouldn't be a document or exhibit coming in that you just didn't know about. You may not know how a judge will rule on portions of it, but that's covered. Where we have the difficulty is with sub rosa. We're frequently in the middle of trial and all of a sudden our client's on the stand and they're setting up for the video of our client doing something perhaps they said they can't do. And we're seeing more and more of that. And so for you plaintiff lawyers out there, I'm telling you what's happening is a major issue is they're doing the sub rosa after the close of discovery. So you're not getting it in advance to prepare. So be aware of that. What we do is a 1987 notice to produce at trial the sub rosa. And we ask for a hearing on the first day, forcing them to turn it over before the start of trial to avoid the surprise. And if they produce it, what I'm getting now, and advise your clients, they're doing sub rosa during trial. So we're totally surprised by it. So the method of dealing with it is object and see if you can see it in advance, try to prevent them from using it, see if they can you can avoid letting them establish a proper foundation, make them bring in the investigator. And then, like we said, look, this stuff isn't easy, right? We're thinking on our feet. What you do then is you attack. You can ask the investigator. So let me get this straight. You followed my client around. You hid in the bushes. You hid in the trash can. You followed the little girl, 14-year-old girl around, did you? You followed her at school. You took pictures of her playing soccer, and all of a sudden, he's the jerk off. But it's fluid, and you'll have to deal with it as it goes. But the surprise evidence you're referring to, probably the most prevalent, and the thing that plaintiff lawyers out there need to really focus on is the sub rosa before, during discovery, after discovery, and during trial.
Hey,
So
Stacie, can I? Oh, go ahead, Morgan.
No, I agree with Dana and Gary. Every trial lawyer wants to avoid surprises. So there are motions in limine, there are lots of procedural ways you try to avoid them. But let me give you an example. This was trial in Boston. And we fought hard successfully before the trial began to keep out the fact that the party we represented, a defendant, a company that was started in Boston, developed some new technology, was not owned by a big Japanese conglomerate, because we wanted to say we're this local company and we're being sued for vast sums of money, unfairly, of course. And we prepared all of our witnesses because we were successful in having the court exclude evidence of the foreign ownership to be prepared for this. The former CEO and then chairman of the board had been carefully prepared on this issue. He's on the stand, and of course he blurts out in response to a question that wasn't directly asking for it, that the company is owned by this Japanese conglomerate. So what do? Boy, at a break, everyone was very excited. I said, well, let's see how it plays out. We ultimately decided that the rest of the day, that evening, let's just ignore it, because we expected the other side would try and play it up. And they did. And they tried to play it up with every witness. And it got to be a broken record. And we thought that jurors are just human beings. It's not terribly relevant to any issue the jury would be asked to decide. And the more the other side played it up, the more they hurt what was a good fact for them. And we could point out in closing argument what they were doing.
And Stacie, let me go back to something that Gary's saying, and I think, it takes 20 years to develop a great reputation, and you can do it in 20 minutes, right? And when you're going to be trying big cases, you want people knowing who you are as having a great reputation. You're going to win cases and you're going to lose cases. I have a great relationship with Gary. We have we have probably 10 cases against each other right now, and probably had 50 over the years. I have tremendous respect, and we get along. And because we built trust, Gary can call me, I can call him on cell phones and work things out. If developing a relationship with your opposing counsel, if you can, it's not always going to be that way. It's hard sometimes. But if you can develop a bit of either a relationship, some respect, guess what happens when things go wrong? You can go to your opponent, and he or she will show some grace, and hopefully you'll show grace back to them. If your witness no-shows, and you're sweating because you've got them under subpoena, they're supposed to be there, and now you're stuck, go to your opponent and say, I got a problem. Would you stipulate to this exhibit coming in? Do I need to call them? Can I rearrange the schedule? Do something like that. When your PowerPoint doesn't work, when your technology stops, because it will, everybody, if you've developed a professional, cordial relationship, which is not just winning at all costs with your opposing counsel, go talk to them. Try to avoid the surprises that way, too. It's amazing what you can work out and eliminate before you get to court, because something is going to go wrong. And by the way, if Gary's in trial against me and his technology just dies and his screen goes black, I'm going to turn to my technology guy and say, can you help him?
Exactly.
That's the way you do it, because I may need him to do that for me on the next trial. And the other thing, too, is the jury's watching. I have never had a juror come up to me and said, we really enjoyed lawyers fighting. That was great. But they have come up to me and said, you know, it's amazing. You two are clearly on opposite sides of this case. Dordick wants $50 million from your client, and you're trying to get it a zero. But you guys got along. How do you do that? And they like that. They actually like that. It's not like TV, everybody. So when you can get along, get along.
No, I agree with Dana completely. Sometimes I see the plaintiff's lawyer struggling to find an exhibit or something, and I'll just have it right there, and I'll go, here, use mine. And the jury thinks that's pretty classy because you're expediting the trial for the jury. You're not wasting their time. So I agree with Gary also. I don't think this unexpected evidence comes in that much against the defendant. It's usually the plaintiff that the defendant springs something on. And that's because when we do our discovery, we try to pin the plaintiff down in every which way possible as to what their theories are, and what documents they have, and who they talk to, and who their witnesses are. I represent employers, so I have a large number of people at my disposal who were involved in this particular problem, and the plaintiff's lawyer frequently doesn't ask for that. They don't ask for information about the person who got promoted, as opposed to arguing they just didn't get promoted. And so they get surprised. I don't think it should happen that much with the defendant. But what's bigger problem for me is when I have a really juicy piece of evidence. And because I do a lot of employment cases, they're very junior high school, they're very salacious, they're very whatever. I have all this salacious stuff, and they bring motions to keep it out all the time. And I want to bring it in for the flavor of what was really going on. So what happened in I think it was my last trial, I represented this really wonderful man who was extremely wealthy. And he went into a potential business deal with the plaintiff. And then he pulled out of it. So there was a business component to the case. But then she went back to him and begged for money, and she claimed he sexually assaulted her. So it turned out at the end, we just tried the sexual assault. Well, he had a very tragic experience where he took his son to college to start school, and he and his wife and daughter stopped for a cup of coffee on the way back. And as they were crossing the street, his wife was run down by a driver and killed in front of his eyes. And his arm was broken, his daughter was injured. Needless to say, his son dropped out of school. So about 1.5 years, 2 years later, this particular plaintiff reached out to him on LinkedIn, and this poor guy had been married for 35 years, didn't even know what LinkedIn was. He was an entrepreneur. And so he invited her for coffee, and he was interested in developing a relationship. So the plaintiff's lawyer knew the story, and he didn't file a motion in limine to keep out the death of the wife or the circumstances. So as I'm doing my opening statement, I start to tell this because I feel the jury needs to know the quality of this man. And he wasn't just a sexual predator. He was a lonesome, broken guy who was looking for a companionship. And he interrupts me in the middle of my opening statement, 352, it's too argumentative. And the judge sustains the objection. So now my client's going on the witness stand, and the judge knows I'm going to ask him because you can't go into the wife's death. I said, Your Honor, but it's very important because it shows his state of mind and that he goes, it's too prejudicial. So I said, well, Your Honor, can I read her deposition testimony? And he said, yes, you can use a deposition of an opposing side for any purpose. So I read her testimony where I asked her, when he went to coffee with you, what did he tell you? And she told us all about the wife's death. So I read it from her perspective. And then I asked my client, did you talk to her about that? And he said, yes. I said, why? He had to pull himself together. He said, for 2 years, I've been struggling with the loss of my marriage, my children. I just was looking for an adult to have a relationship with, someone that I could talk to. And I shared this with her. Well, I think 3 people on the jury were crying. I could hardly keep it together myself. It was so powerful. I got it into evidence because I had asked her about it at the deposition, and I could use her deposition for any purpose. And so I didn't use it to cross-examine her. I used it to tell the jury what she said and then say, did you say that and why? So there are ways to get around it. You have to figure out if your evidence is relevant. You can get it in.
Linda, that was so powerful. I wanted to object during your lecture just now. Linda, since you're with ADR, you want to talk about mediation a little bit?
I'm not with ADR. I'm still trying cases.
I meant Stacie. Stacie, would you like to ask us?
Yeah, well, yes, and thank you for sharing all that. Let me just ask you generally about mediation. So with mediation, what type of preparation do you do so that you can optimize your settlement results? Do you share briefs? Do you share all your information? Do you share trial arguments? Do you hold some of it back so that you can surprise them at trial should the case not settle? How do you generally go about approaching mediation? And any of you who want to start at this one. Gary, do you want to jump in? Because we have you on the plaintiff side and everyone else.
Yes, I'll give the plaintiff perspective. So the people say to me, we just had a settlement this month with one of the medias for $42 million. And people say, well, how do you get 20, 30, 40, $50 million settlements? And the key from the plaintiff perspective is you have to help them help you. They don't mind paying a significant amount of money if it's documented in the claims file, and if the attorney can look good on his handling of the case or her handling of the case, and there's sufficient basis to justify what you want. But if you're a jerk plaintiff lawyer that doesn't give them what they need, doesn't do the appropriate, doesn't assist them appropriately, you're never going to get it. So there should never be a confidential plaintiff settlement brief, ever. If you want to get money, I don't want the defense lawyer telling the adjuster the value of my case and why. They're good at their job. Their job is saying why it's not worth money or why it's worth less. I want them, they can use their skill, but I want to give them the tools they need. I want to send it to them, and I want the adjuster and the defense attorney and all of them to read my words of why I'm asking for the money I'm asking, to read about the suffering, to look at the photographs or maybe a day in the life video. I want to give them everything they need so they can be prepared. And one of the words of wisdom I've heard from my defense friends, and Dana and Linda can talk about it, is they need it at least 2 weeks in advance. We do everything the night before it. 2 a.m, we're working on the mediation brief for 9 a.m. that day. But the reality is, if you want them to put money on it, they're committing it, and they can speak to this 2 weeks before. If you have something as a plaintiff lawyer that's some golden impeachment you don't want to disclose, well, then do a supplemental paragraph or tell the mediator about that when you get there. But the most important takeaway here from the plaintiff, and the way I get big settlements, is I do a very detailed brief, providing them with everything they need. I get them in advance of the mediation, if I can, my life care plan, the medical specials that document big numbers, so they can prepare, because the lawyer is going to write a report to the carrier saying, this is the range I recommend we settle in. And I want them to have everything. So in the end, they don't mind paying us the money, but they have to look good doing it. The adjuster has a boss, and they want to know why you paid that kind of money. So help them help our clients, and you'll be a lot better off in the long run.
We represent an equal number of plaintiffs and defendants. I agree with Gary, and I'm going to guess the other panelists would also have a similar point of view, that both sides disclosing their mediation brief in full, not only to the mediator, but the other side, makes a lot of sense. Good lawyers on both sides aren't going to be surprised or educated by anything in the mediation brief. It's very rare that there's some terrific little gem that's going to be a big surprise at trial. So full disclosure makes sense. I would say our approach, my approach to mediation or settling a case is there is always a time to pick up the telephone, because there are many who think that if the most recent decision was adverse to our party's side, we shouldn't pick up the telephone. Well, if that were the case, no one would ever talk, because the most recent decision in the case was favorable to one side or the other. And I also am very much in favor of educating whoever we're representing that mediation is a process. It's a process leading up to the first mediation meeting. We should assume that there won't be a settlement. If there's not a settlement, it's a conversation that's ongoing. So let's not take positions that make it more difficult to have a successful discussion and successful settlement later. Sometimes it takes a long time to get there. Drawing analogies to other areas of life is always fraught with dangers. But if one thinks about great conflicts, including some great conflicts we have in the world today, it's an ongoing discussion. If there's ever to be some success, it doesn't take place in 1, 2, 3, or 5 meetings. It takes place over a long period of time. And that's often the case when there's a lot at stake in litigation.
So
go ahead, Linda, please.
so my case is usually the plaintiffs have 12 to 15 causes of action. You know, there's always at least 7 or 8 wage and hour causes of action, and then there's retaliation, discrimination, harassment, failure to prevent, blah, blah, blah. So I think a defendant is poorly represented, quite frankly, if their lawyer does not share the mediation brief. I think, and I don't think a mediation brief should ever be a motion for summary judgment. The mediators have done this 1,000 times. They know what the law is on harassment, discrimination, whatever. But what they don't know are the facts. And the plaintiff's lawyer only knows the facts that their client told them, which may be selective in some instances. So I think a mediation brief should be incredibly fact specific, with exhibits showing how they signed their time cards, that, oh, my time was always correct. Never, you know, I never worked overtime. I never missed a meal period. Let the plaintiff's lawyer see those documents. Don't tell them about it. Let them see it. So put together a very fact-specific mediation brief with whatever emails you have and documents to show that you did things right, and share it with the other side. What have you got to lose? You've just spent a ton of money going to mediation. Maybe the case will be resolved. You keep it to yourself, why would anyone settle with you? That's my sense.
So I'll round it out, Stacie. So I think there's a consensus here. We're going to make it unanimous. Share your brief with your opponent. If I've got a good case and I've got good evidence and I got good witnesses, I know that if I show a Gary Dordick that, he knows how to evaluate the case. He'll take that into account. He'll say, hey, maybe I'm a little too high. I didn't realize this, or I didn't consider that. And he'll reconfigure his evaluation, and that's okay. By the way, Stacie, I'm going to say, speak up for someone like you. Don't waste time in a mediation brief teaching the mediator who's done this kind of case 100 times. And employment, someone who does employment, don't tell them the black letter stuff in employment law. A tort case, don't tell them what negligence is. Don't waste your time on that stuff. Your pick your mediator because he or she is sophisticated and experienced in this area. Now, sometimes I might have a sensitive topic in a mediation that I don't mind telling Gary, but I'm worried that if he shows it to his client, a widow, something like that, let's say there's a widow and the deceased person had some baggage. I'm just gonna leave it at that. I might call up Gary and say, Gary, do me a favor. I'm going to send you my brief, but I need your commitment. I don't want you showing it to the widow because she might be offended by some of this, and I want you to know what we know, but I don't want her to be upset. Filter it. You tell her what you want to tell her. And someone like Gary say, sure, thanks for the phone call. I'll be sensitive about it. So call if in doubt. Gary brought up what I call the Jerry Maguire moment. Help me help you. For you plaintiff lawyers out there, sometimes you don't appreciate that someone like Linda or me or Morgan in our room when we got the defendant actually can be an ally. We're not idiots. If we see problems in our case, if we see that you have value, we're going to tell our side that. While we're advocates, we're not idiots. We're going to say, Gary's got a good point or a good case. Look at this. So the old help me help you is absolutely true. Do not assume the defense lawyer is fighting every single issue you're raising. You wouldn't believe that we have mediations in our rooms, just like you have mediations in your rooms with your client. And sometimes we're telling a general counsel or a risk manager or an insurance carrier person that they are undervaluing or not appreciating a certain thing. So just help us do our jobs and give us the information we need. Two more points. Don't drop something on me in the last minute. Gary, I actually am going to modify. 2 weeks is not enough. Because if Gary has a life, this is the classic for all you plaintiff lawyers out there. You walk in the mediation and drop a $9 million life camp plan on me. There's nothing I can do with it. I needed that 4 weeks ago so I could look at it, talk to my expert, put together an evaluation and send it off to the carrier or general counsel or risk manager and say, here's the $9 million life care plan. Here's what I think of it. And they can factor that into their evaluation and come with the right authority based on our collective roundtabling of it. And the general counsel and the risk manager or the carriers all have their jobs to do, as Gary says. Give them some runway to do their jobs. Don't expect them to pivot in 48 hours. So give us a lot. The last thing I'll say is some of you do very nice day in the life videos. They're very polished. That's not going to score a lot of points with me. I've probably deposed the widow. I've deposed the plaintiff. I've deposed the people. I already know if they're likable or not. I know the facts. I know what happened. I've got the damages. You're going to put together your greatest hits. It's not what I'm going to evaluate on. I'm going to look at objective evidence. Give me the medical records, the reports, the testimony. That's what I'm going to go with, not your polished day in the life video. That's really not going to move the needle on my side, I'm going to tell you.
I think that the point Morgan makes, it's also important for all of us to prepare our clients that it may not settle. I mostly tell my clients often in the cases we handle, which are the larger cases, it may take 2 or 3 mediation sessions. So don't be disappointed. Don't come there with your expectations that if it doesn't settle today, it's terrible, we're going to trial. We have to manage our clients' expectations to keep them happy with what we do. So letting them know more about the process before we get there. And the other thing that's really important for all of us, and particularly plaintiff counsel, is that there's work you have to do before the mediation. For example, we get there oftentimes, and then they get our brief, and our demand is over the primary carrier's limits, and the excess carrier hasn't been put on notice, and they're not there. So it's set up for failure. So you need to make sure, are the right people there? Are the right carriers there? Do they have an understanding of what your demand is to make sure the people they need to make decisions are there? So we often like to do a little negotiating before we go to mediation nowadays to get a sense of where they're at and where we're at. And also timing is very important. Most of our cases, the mediations get more serious the closer we get to trial. Now, there's some exceptions, but oftentimes I say to my associates, why are we mediating 8 months away from trial? There's too many more variables. Or find out from the defense. Do they need expert depots before they'll settle? Or do they need a ruling on the summary judgment before this can be meaningful? So better communication often between the plaintiffs and the defense make for a more meaningful mediation.
Gary, I'm going to say one thing, though. I've heard recently a phrase called discovery mediations, where people show up and the media will come in and go, I don't really think the other side is really ready to settle the day. They're just trying to get some basic information, trying to find out stuff. And it's very frustrating for me because I take a mediation seriously. I think most of us do, but I've done a lot of work. I've written a pre-mediation report. I've probably had at least 1 or 2 roundtable calls with my client, the GC, the risk manager, or carriers, and or all of them. And we show up ready to mediate. You might not like the numbers. That's okay, but we're ready. Don't show up and just say, well, on your side, you don't have the case of value. You have no idea you haven't focused it. You haven't mocked it. You don't know what your numbers are. We're just going to go and kind of feel them out and see where they are. That's a waste of time.
As a mediator, let me say, I love this advice you're giving, and I want to just echo all these sentiments because this advice makes it a lot easier for us to get your cases resolved as well. So I really appreciate it. If you've noticed, I have a smile on my face. I'm shaking my head. That's right. That's right. So I appreciate all of that. We are almost out of time. So I just want to turn to the 4 of you and ask you for any closing thoughts that you may have. And Morgan, let's get started with you this time.
Well, just to tie together some comments by the other panelists with which I agree. For trials and mediation, we're dealing with facts, not characterizations, but the underlying facts. And probably almost a century ago, there were studies of juries and what they responded to. They were called the Chicago studies. They got a little mischaracterized along the way by numbers of pundits, but they tended to stand for the proposition that many jurors would make up their minds, an overwhelming percentage, after hearing opening statements. Now think about that. Well, then why don't you just skip the trial? Everyone would save some time and money. But it's not surprising because you expect that the lawyers on both sides, good lawyers, competent lawyers, would comply with the rules, and if they didn't, the judge would force them to, which is an opening statement, state the facts. Not argument, facts. And if jurors or other decision makers have heard the facts being put forward in the best form possible for each side, they may decide the case. So that's true with trials. That's true with mediations. And it's also an underlying theme that a number of the speakers have mentioned, which is the credibility of a party's position and hence the lawyer's position in a case is also very important. And that's all in opening. And that's part of my closing statement for this panel.
So I am a huge advocate of spending time on exhibits before trial so that when you present your case to the jury, it has some logic associated to it. So if you have a breach of contract case, I would suggest that you make the contract in dispute Exhibit 1 as opposed to Exhibit 52. And I would suggest that you do issue packets so that you have all the exhibits related to one issue together so that the jury is not asked to look at Exhibit 16 and then 178 and then 42 and then 295, because that doesn't help the jury. And it doesn't help you in your thinking because you may approach a case chronologically. Mostly you're going to approach it by issues. In an employment case, if someone's been a 20-year employee, it's very interesting that they got outstanding performance reviews in year 1. It's not really very relevant to year 20. So organize your exhibits in a way that the jury can use them and makes it easier for you to make your presentation. And I think a trial will go smoother. So that's my pitch for working on exhibits beforehand.
All right, Dana.
So less is more in trials. So I'm going to follow that theme here because it's almost ending time. Less is more. Stay calm. Something will go wrong. The calmer you are, the better you're going to do when that goes wrong. And the way to minimize the likelihood of something going wrong is to prepare. Be very prepared, everybody. Don't wing anything. Really be prepared. Know your exhibits. Know your whatever about your case. And then my last takeaway is this. Reputation is everything. We all want to win. No one likes to lose. But your reputation is going to last a lot longer than that trial. Just remember that.
I'll round it out with to win trials, what you need to understand is there's a tremendous amount of strategy. The order you call witnesses, the order you present witnesses, which questions you ask first, which questions you ask last in your examination and cross-examination. So if I can give you one concept to think about when you leave here, it's what Gary says is in trials are playing chess. Good trial lawyers play chess. Inexperienced ones or not very good ones are playing checkers. You're thinking 4 moves ahead. If I ask this and they respond that, I'm going to say this and then they're going to say that. With every aspect of the trial, think about it. You're playing chess, not checkers.
Well, thank you all so much for your insights. This was such a treat, and thank you all for attending today.
Thank you.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.